Our speaker tonight, as you know, is Justice Clint Bolick, and he began his career not as a judge, but as a constitutional lawyer. And when his first judge was on the Supreme Court of Arizona, so that's a way of going right to the top. Before that, he was a co-founder of the Institute for Justice, an organization that many of you are also aware. Thank you. And he worked on the issues of school choice, fewer regulations, and property rights. And most recently, before becoming a judge, he was at the Goldwater Institute. And the quote on Wikipedia is, he was the VP of litigation where he sued government bureaucrats on behalf of citizens' rights. So right there, it sounds like a good way to do that. So tonight, Justice Bolick will talk about the third arm of government that we don't maybe hear that much about. Of course, you know, the executive and the legislative, but this is about the judicial. So with great pride and happiness, I'm happy to welcome Justice Clint Bolick.
Thank you so much, Erica. Thank you, Joel, and welcome. And thanks to each and every one of you. I wasn't going to start out with this anecdote, but when I heard the very strong round of applause for Ann Coulter, I thought I would begin with a brief anecdote about Ann, who I've known for many, many years. And I might not be here tonight if Ann had not made a different decision career-wise than she made. But when I was at the Institute for Justice, Ann, many of you probably know that Ann was a lawyer before she became the celebrity and commentator that she is today. And she applied for a position at the Institute for Justice, and we offered her a position working as an attorney for IJ. And she turned us down. And the reason she turned us down was that Washington, D.C. had adopted an anti-smoking ordinance, and she was wondering where the heck she was going to be smoking her cigarettes. And it would not be at our office, unfortunately for her. But subsequently, we hired a different lawyer, and that lawyer and I organized a group of parents in South Central Los Angeles to fight for school choice, to file a lawsuit arguing that the quality of education in South Central Los Angeles was so appalling that it violated your state constitution's guarantee of a high-quality education, and they sought a voucher remedy, essentially the opportunity to leave the school system altogether. And my colleague and I went into South Central Los Angeles to meet with parents at a little shopping center. And unbeknownst to us, a riot was beginning to form, and it became a very significant event. And we were among the first people attacked. We were attacked by rioters who came out into the road and started attacking our car with 2x4s. And we drove off, and you know, sometimes civilization doesn't leave your mind. I remember as I'm driving through the red light to get away from the marauders, I'm worried that I'm going to drive over their feet. Nonetheless, we get to the shopping center where our meeting is taking place, and the TV is on. And I'm saying, we need to call the police and let them know what's happening here. And of course, the police knew, and they were nowhere in the area. And we went on to have the meeting. The shopping center was burned to the ground that night after we left, and one of the parents drove us to safety. But often since that time, and my colleague and I obviously escaped with our lives, often during that time, I thought to myself, what if Ann had taken that job and she had been with me that night instead of my friend Dirk Raghaveen? You know what she would have done, she would have gotten out of the car. and confronted the rioters, and I suspect that neither Ann nor I would be with you today. So thank you, Ann, for turning down that position. I was disappointed at the time, but it turned out just well for both of us. It's so great to be back in Northern California. I have a tremendous number of connections here. When I was a youngster, I lived for a year in the beautiful metropolis of Daly City, California, and one of my classmates at Ben Franklin Junior High School went on to become Congressman Jim Rogan from Southern California, just a phenomenal American. Like Erica, I went to UC Davis. I went there for law school. And as she said in her introduction, I was very, very eager. I just could not wait to start suing government. And so I didn't wait. My first two lawsuits were as a student. I first sued the president of the University of California, which did not endear me to my dean. And then I went on to sue the city of Davis, just on general principle. No, I mean, but in any event, until becoming a justice, that's what I gleefully did for a living, and I'm happy to say that we won many more battles than we lost, and I'm now so honored to be on a tremendous court that values the rule of law very, very highly, and to be addressing the issues of individual rights and constraints on government power from a different perspective. I want to commend you for your involvement in this organization and with advancing the principles that you hold dear. I'm sure it's a view that you agree with, that Silicon Valley, of all the places in Earth, should be the epicenter of freedom. There is no place on earth that has more prospered from the soil of freedom than this place. And so I hope that you will continue to spread the philosophy of freedom to others here in Silicon Valley who have prospered from the freedom that they have, and I hope that they will stay the course. I was appointed to the Arizona Supreme Court by Governor Doug Ducey in January of last year, 2016, so I'm still fairly fresh in my role. And with my appointment, I scored a number of firsts. I am the 44th justice appointed to the Arizona Supreme Court, but I'm the first ever independent. Every other justice has been either a Republican or a Democrat, and so I am the first who is not affiliated with a party. I am also the first justice to hang up on the governor when he called to offer me the position. This was not intentional. It was, and I'm embarrassed to admit it, in Silicon Valley, of all places, I am a total technophobe, and to this day, I cannot figure out how to get off one call and onto another without disconnecting both people, and that's exactly what happened. My friends, though, have told me that the better explanation is that I was just exhibiting my view of the proper separation of powers. But nonetheless, fortunately for me, Governor Ducey took my call when I called him back, and he offered me the position. I am also the first member of the Arizona Supreme Court, and possibly any Supreme Court in the country, to be openly inked. Among the many clients I represented over the years were the owners of a tattoo studio in Tempe, Arizona, which is a place that houses a major university, so you would think that there would probably be some tattoo studios there. And these were salt-of-the-earth people. They had a successful studio in Mesa, and they got a permit from the city to open a tattoo studio in a half-empty strip mall. This was during the most recent recession. and they invested $25,000 and refurbished the place. And then the city decided, yeah, we really don't want a tattoo studio here, so they revoked their permit. And I read about this on a Saturday as my daughter was in gymnastics class, and it was so nice to be able to get really irritated about something and to be able to call the person and say, you want to sue? And the answer was, I can't afford a lawyer. And then my response, which I always loved giving, was, I'm free. And so we filed a lawsuit, and I used to get very, very passionate about my cases. And as we were filing this lawsuit and trying to get their permit and their opportunity to earn an honest living back, I vowed, you know what, if we win this thing, I am going to get inked. And we did win, and my wife said, you know what, I really wish that you would not get a tattoo. And at that time, she was thinking of running for office, and she asked me what I thought about that, and I said, I really wish that you would not run for office. And she did, and I did, and we're still happily married, I'm happy to say. But I have, befitting my status as a desert dweller, I have a tattoo of a scorpion on my typing finger. I have typed every book, every article, every decision, every brief I've ever written with one finger, and it now bears a tattoo of a scorpion. I have been after my colleagues to get inked, and I don't know, I thought I was a fairly persuasive guy. So far, not a single one of them has gotten openly inked, so I'm going to continue working on that. My talk tonight is about an essential yet, as Erica mentioned, often overlooked part of the story of American freedom, and that is a judiciary committed to the rule of law. It's something that we often take for granted, but we can ill afford to do so. There are two recent incidents that I read about that really show how unique America is with regard to its judiciary and how important it is to safeguard that system. In China, as you may know, there are now a lot of Chinese students studying in the United States, many of them law students. And a lot of American lawyers go over to China and they talk about our system. And the Chief Justice of the Chinese Supreme Court apparently grew very agitated about the infiltration of Western ideas of justice in China, and grew very, very concerned about it. And in an article in the New York Times, he was quoted as saying, we need to banish these Western ideas because the purpose of the judiciary is to sustain the regime. Just imagine that. If we had a judiciary whose purpose was to sustain the regime, how different our society would be. Venezuela recently, the Venezuelan Supreme Court abolished the legislature, the national legislature, and assumed its powers. Imagine that. I mean, you know, our congressional ratings are not very high, but just imagine what they would be if the Supreme Court said, you know what, we're going to start passing laws from now on. And, you know, as angry or frustrated as people can legitimately be about some decisions that courts make in our country, when you think about the judicial systems in other countries, the fact that if you seek to enforce a contract or your private property rights or something like that, you will walk away empty-handed even though you deserve to win. It really makes you realize how important the judiciary is here in the United States and how lucky we are to have a judiciary that will enforce the rights of individuals. The framers of our Constitution considered an independent judiciary essential to preserving liberty. And the role that the framers intended for the judiciary was to act as a limitation on the powers of the other two branches of government. It was the only body capable of holding the executive branch and the legislative branch to their defined limits of power under the Constitution. Additionally, only the judiciary was thought to be capable of vindicating the individual rights in our Bill of Rights and our Constitution generally. The framers, as you know, considered the judiciary the least dangerous branch of government for precisely this reason, because when it exercised power, it would be restraining the power of the other two branches of government. But the framers did warn in the Federalist Papers that the judiciary could become a very dangerous body if it ever took on the powers of the executive or the legislative branches. And indeed, when it has done so, and it has done so in many instances, it has been a very dangerous branch of government. So there is a constant battle going on in the judiciary between those who believe that, that the Constitution is an evolving document, that is a document that the judges should look at and say, really, in our time, how should this read? Not how does it read, but how should it read? And the judges in our system who believe that the Constitution is eternal, that there is a way to amend the Constitution. It's not by judicial legislation, it's by the amendment process that the framers set out in the Constitution, and that it's illegitimate for judges to themselves amend the Constitution. And the resolution of that enduring battle is absolutely vital to the future of freedom in our country. As a result of that, in my view, and I think history, especially recent history, really bears this out, the most important and enduring decision a president will ever make is who to appoint to the United States Supreme Court and to the federal judiciary. Justices usually far outlast the presidents who appoint them. And just think about it. Ronald Reagan has not been president since 1988. But as of only a year and a half ago, two members of the United States Supreme Court, and now one, were appointed by Ronald Reagan. Boy, that is a legacy that far outlasts the president. Justice Kennedy remains on the court. He is the remaining Reagan appointee. And the impact of those justices can be extremely significant as well, for both good and bad. In fact, Dwight Eisenhower, some of you may be familiar with this quote, was asked after he was finished being president what his biggest mistakes were as president. He said, "The two biggest mistakes that I made as president are both serving on the United States Supreme Court." So they definitely outlast the president, and if the president goofs in his or her judgment, that can be an enduring thing as well. The appointment of justices today is more consequential than ever for two main reasons. The first is that the value of lifetime appointments has increased. The framers, in their wisdom, said, in order to be a truly independent judiciary, we must provide lifetime tenure to our judges. And in fact, justices have tended to often lead very long lives. In fact, there is a saying that if you wanted to live a long life, be appointed to the U.S. Supreme Court. If you wanted to live a short life, retire from the U.S. Supreme Court. And so justices have tended to stay for a very long time. My very favorite quote from Thurgood Marshall toward the end of his tenure, he was interviewed by the Washington Post, and they asked him if he planned to retire anytime soon. He was in his 80s by that point, and he said, absolutely not. Said, I was appointed to lifetime tenure, and I intend to serve every single day of that. Not only that, I plan to live to be over 100 years old. And not only that, when I finally die, I plan to be shot by a jealous husband. That's quite the aspiration. But nonetheless, he served on the court for a good long time. But of course, longevity in general has dramatically increased lifetime tenure. At the time of our nation's founding, the average age of appointment of a Supreme Court justice is about the same as it is today. It was age 50 at that time. However, life expectancy at that time was in the 30s. So the average age of the appointee was older than the average age of death. So that the logical explanation would be lifetime tenure would be like you die instantly as soon as you were appointed. And some of these folks did live a good long time, but indeed lifetime tenure did not mean all that much. Today, the average age of a Supreme Court nominee is 52. Life expectancy for a 52-year-old is about 85, which means that the average term of a U.S. Supreme Court justice today is roughly 32 years. That is 8 presidential terms. When you think about that, that is a breathtaking legacy. And so the importance of Supreme Court appointments is going to outlast any presidency. Clarence Thomas, for example, was appointed at age 43. If he lives to the same age as his predecessor, Thurgood Marshall, he will set the all-time record for longevity on the U.S. Supreme Court and serve for 40 years. And of course, he could live longer than that and serve on the court longer than that. Presidents and senators are figuring this out. And so they're appointing nominees at an earlier and earlier age. And you may have read in the most recent nomination that basically if you had a 6 in the first digit of your age, you were probably not going to be considered for the court. Mitch McConnell, a person who is not known for his ribald sense of humor, was recently reported as having had a conversation with Neil Gorsuch, in which Gorsuch said, I would really hope to serve for 20 or 25 years on the Supreme Court if I'm confirmed. And McConnell scoffed and said, no, think Strom Thurmond. So who knows? But in any event, this is obviously, part of the calculus now for the U.S. Supreme Court. The second reason why the appointment of justices is more consequential than ever is that the science of predicting judicial opinions and judicial philosophies has grown better than it ever was in the past. Both Abraham Lincoln and Franklin Delano Roosevelt tried to pack the U.S. Supreme Court. In Lincoln's case, he was trying to pack the court to uphold his controversial executive orders during the Civil War, and Roosevelt, of course, was trying to pack the court to uphold the New Deal. But both of them failed ultimately because they appointed justices who were very independent, very unpredictable, and often went in very, very different directions. Richard Nixon, the same thing. But it has been a long time since a president has nominated a justice who did not live up to his expectations for that justice. In fact, the most recent such appointee, David Souter, isn't even on the court anymore. And that's not to say that the justices are in philosophical lockstep. There's lots of unanimous decisions. They are independent thinkers, and they often go their different ways. But generally speaking, you can fairly confidently predict on a controversial constitutional issue how a justice will come down based on the party affiliation of the president that appointed that justice. And that is now permeating not just the U.S. Supreme Court, but the lower court decisions as well. One thing that struck me recently, and I'm not allowed to talk about, and I don't intend to comment at all on pending cases. But for example, the recent challenges to Trump's immigration executive order, as I've been following it, almost all of the judges who have voted to strike down those orders were appointed by Democrats. Almost all who voted to uphold them were Republican. And what that suggests to me is that presidents are taking the philosophy of judicial candidates very, very seriously. Well, we are now in the 26th year of a fairly consistently conservative U.S. Supreme Court. And what I mean by conservative is a court that generally hews to the constitutional text rather than reinterpreting the text to mean different things. And this has had huge real-world ramifications in at least 7 areas of the law, probably all of which are important to each and every one of you as they are to me. And in no particular order, the first is private property rights. We have numerous protections of private property rights in our Bill of Rights, and yet they had been largely eviscerated by previous courts, especially in the area of takings, where the government would take property not just through an overt use of eminent domain, but through regulation that would actually lower the value of your property and reduce your ability to use your property as you intended. And that has largely changed. The major exception to that, of course, was the Kelo eminent domain decision that I'll talk about in a little greater detail. But by and large, there is far greater constitutional protection for private property rights today than there was before the nomination and confirmation of Clarence Thomas, which was, I think, the turning point on the court. The second is the area of racial preferences. That is the idea that government may discriminate for benign purposes to advantage individuals, either for the sake of overcoming a disadvantage or to promote racial diversity, particularly in universities. Again, the court just retreated from that in that area in the University of Texas case, but again, there are far greater constitutional restraints on racial preferences today than there were 26 years ago. An issue near and dear to my heart, because I litigated this issue for a majority of my litigation career, school choice. The idea of school vouchers or other forms of allowing children to go to the school of their choice using their share of public funds. This is an issue that was confronted by the Establishment Clause. And the Establishment Clause reads that Congress shall make no law respecting an establishment of religion. And this is one of those provisions that the courts had really rewritten. In fact, they rewrote it so successfully that we now think of that as separation of church and state today. There is no strict separation of church and state in the U.S. Constitution. There is a prohibition against the establishment of religion. When I see those two terms, I see two very, very different things. But the court had really done a very confusing rewriting of the Constitution, and the current court has really changed that and limited the scope of the Establishment Clause. The case that went to the U.S. Supreme Court that I litigated was a case involving the Cleveland voucher program in 2002, and it was upheld by the resounding vote of 5-4. And just to kind of show the divide on the court, the dissenters in that case argued that if the court upheld that voucher program, that we would see religious strife of the same degree that we saw in Bosnia and Northern Ireland. Now, I just, of course, as a litigator, thought that was a tad ridiculous, and in fact, we have not seen any such religious strife flowing from that decision, but nonetheless, that illustrates the divide. An issue, of course, that a lot of people feel very, very strongly about is the Second Amendment. And of course, the United States Supreme Court, reading the Second Amendment and applying its plain meaning and its historical meaning, ruled that the Second Amendment provides an individual right to the ownership of guns. And that obviously is an issue that had not been resolved before then. The issue of political speech, particularly the exercise of political speech through campaign contributions. Before the current court, political speech could be very, very heavily regulated by state governments and the federal government. Today, those restrictions are far less permissible. And again, the court reading the plain language of the First Amendment that says Congress shall make no law abridging freedom of speech, and giving meaning to those words. The Commerce Clause of the United States Constitution, and now I'm getting into kind of nerdy jargon here, but this could not possibly be more important. The power of the federal government to regulate commerce had basically been interpreted by the Supreme Court to mean the power to regulate anything, even the power to regulate what individuals did in their own homes that never passed into the stream of commerce. One of the most infamous cases, Wickard versus Filburn, where individuals were growing food on their own farm for their own consumption. Congress regulated that, and the U.S. Supreme Court said, well, of course it's a commerce case, because after all, these people are not buying something from some other state. Therefore, it affects commerce. Well, again, a plain reading of the Commerce Clause would have you believe that it actually requires commerce for Congress to regulate it. And the U.S. Supreme Court has rolled that back pretty significantly. And then an area also near and dear to my heart, the issue of federalism, which I think is more important today in a divided red and blue America than ever before. It's so important that states be able to reflect the maximum possible degree, the maximum possible constitutional degree, the values of their citizens, whether it's for greater regulation or greater freedom. And federalism was reduced to what the U.S. Supreme Court in the 40s called a truism. And now it's vital again. Even in the Obamacare case, the court ruled 6-3 that federal funding could not be used to coerce states into adopting the federal government's Medicaid or Medicare regulations. And so federalism now is alive and well. Nearly all of those areas were 5-4 decisions, nearly every single one. So that the switch of a single vote in any of those areas could be very, very decisive and very, very sweeping. Am I optimistic about what the future holds with regard to the U.S. Supreme Court? Well, I am fairly optimistic. Right now, the court's fulcrum is California's representative on the U.S. Supreme Court, Justice Anthony Kennedy. And on the one hand, Justice Kennedy is definitely more conservative than not. And I know all of you can think of instances where the not part is true. But generally speaking, for example, in fact, on all of the areas that I just listed, Justice Kennedy has voted with the conservatives more often than not. But I have to say that I view Justice Kennedy's decisions as being increasingly unmoored to the rule of law. Even decisions that I agree with, and in fact he wrote the decision in a case that I argued in the U.S. Supreme Court involving the interstate transportation of wine, sale of wine to consumers, which people outside of California care very, very deeply about. And the court upheld it 5-4. And even that decision, while I was so grateful that Justice Kennedy wrote the decision, I thought it could have been much, much stronger. He's of late tended to focus on things that are wonderful values, like what he calls the constitutional right to define and express one's identity, nobility, dignity. All of these things are wonderful, but they're not constitutional principles. And I worry about a court, even when I agree with a decision, hitching its decisions to things like nobility and dignity, because they are in the eye of the beholder. They are not words that have clear, ascertainable meaning. And when you give judges words that have no clear or ascertainable meaning, they can invest their own views on this subject. I recently had a dust-up with regard to a decision by Justice Kennedy in a criminal case. And I did not practice criminal law, but I'm finding the criminal cases often to be among the most interesting on our court's docket. One of the areas in which the court has been very active lately has been the area of juvenile killers and what punishment that they can be meted. And one of the areas that the court has essentially amended the Constitution is in the cruel and unusual punishment context, which they have reinterpreted to be cruel or unusual punishment. If it's either, it's unconstitutional. Now, of course, I disagree with that because the words of the Constitution say cruel and unusual, and obviously for a reason. Nonetheless, the court several years ago held that juvenile killers cannot be sentenced to death. More recently, the court held that juvenile killers cannot be sentenced to life imprisonment without possibility of parole unless there is a determination made that they are, at the time of their sentencing, irreparably corrupted. And in a recent decision by Justice Kennedy, he said, a court has to determine, and this is all coming from, I don't know where. It is not coming from the words of the Constitution. But, and in fact, he gave a hint as to where this was coming from, which I'll mention in a moment. But he said there has to be a determination that the youth at the time of the murder was irreparably corrupted, as opposed to this being an exercise of, and these are the words out of the decision, transient immaturity. Transient immaturity. And I wrote in a concurring opinion in my court applying this decision, which we have no choice but to do. Transient immaturity is when my 12-year-old daughter slugs her 15-year-old brother. It is not when a 17-year-old commits a cold-blooded, premeditated murder. And the court then went on to say something else, and this bothered me even more than the transient immaturity language. The court said it is our instinct that the vast majority of juveniles who commit murder are not irreparably corrupted, and therefore, in the vast majority of cases, they must be given parole. This is like a crystal ball kind of thing, and getting into the minds of these people. And I found that to be so bereft of constitutional mooring that in an opinion in which we now have to go back in the state of Arizona and the state of California, all 50 states, and re-sentence every single juvenile murderer who was not given the possibility of parole. And some of these go back decades, and the courts have to figure out whether or not at the time they were convicted and sentenced. They were irreparably corrupted. This is, and you don't read about cases like this very often. They're not, front page news. But as I go about my job and I have to apply in the area of federal constitutional law, decisions of the United States Supreme Court, when I see cases like this, I just think to myself, there's something seriously wrong. Having said that, I think that the glass is more than half full, and I think that the glass got replenished by Justice Neil Gorsuch. I had the occasion to read a couple of dozen of his opinions as a federal court judge in the 10th Circuit, and I loved what I read. And I was actually inspired by what I read. And there were two aspects of it that I will share with you. The first is that no matter what the issue was, Judge Gorsuch always started with the text of the Constitution or the text of the statute that he was applying every single time. He credited opposing views. He acknowledged in some cases that there might be different outcomes, different meanings, ambiguities, and so forth. And as a textualist, and this is something I really, really need to emphasize, if you were a genuine textualist, if you were a judge who genuinely believes in enforcing the rule of law, sometimes, and he said this at his confirmation hearing, sometimes you are going to produce outcomes with which you personally disagree. And I can say that personally in a year and a half, that there have been multiple cases that I have joined or written that I would not have supported as a policy matter. But again, I am not a legislator, I am a judge. And sometimes that means that you enforce the law in a way that comes out in a way that you disagree with. And I saw instances where I think he did that. But he unfailingly starts with the text, and if the text is clear, that's the end of the analysis. You don't look to foreign law, you don't look to instincts, you look to the law. The other thing, and this was also inspiring as well, Gorsuch is one of the nicest judges I have ever read, and he is always complimentary of his colleagues, sincerely so, and even to the divergent views with which he is disagreeing. And as you may have heard, this was not always the case with his predecessor, Justice Scalia, who sometimes could be a little caustic in his commentary. I think that Gorsuch is a philosophical heir to Justice Scalia, but he is a bit more of a sweetheart, in at least in terms of his jurisprudence. The prospects for change on the court are significant. 3 justices are in or nearing their 80s, so this president may have further opportunities to affect the composition of the court. And I hope that this president or any president will look for candidates like Justice Gorsuch who adhere to the rule of law. One other source of my optimism is the area that's closest to home for me, and that is state courts, enforcing state constitutions. We often talk about our devotion to the Constitution. Well, of course, all of us have 2 constitutions, and it was our state constitutions that were intended to be the primary source of the protection of our rights. And indeed, every state constitution contains greater constraints on the power of government and greater protections of individual rights than the national constitution does. And too often we overlook state constitutions as an independent source of our rights. What is really nifty about state constitutions is that state courts can interpret them to provide greater freedom than the national constitution, but they cannot interpret them to provide less protection than the federal Constitution. I call this a freedom ratchet because you can only decide in one direction. I mean, obviously, if you decide your state constitution gives you less protection, then the federal Constitution steps in and gives you greater protection, and it's really a tremendous thing. Just to give you one example of a case that I litigated a few years ago, most state constitutions contain a provision that I wish was in the federal Constitution. It's called the gift clause. And the gift clause prohibits gifts of public funds to private corporations, individuals, or associations. There is, as you can imagine, no such provision in the US Constitution. We use that to strike down taxpayer subsidies of shopping malls in Arizona. And you can imagine, and you know, as Californians, you know that the myriad instances in which taxpayer funds are given to private individuals for various purposes. And I am happy to say that our Supreme Court, before I was on it, did rule that subsidies of private corporations are unconstitutional. That's just one example of the ways in which state constitutions can provide greater freedom than the US Constitution. I hope that you will all engage in future debates over the shape and direction of the judiciary, both here in California and at the national level. Obviously, the President, the Senate, and the Court of Public Opinion are all implicated by this, and all of you can be influential in directing how that turns out. I want to finish by again saying, and again, I acknowledge the tremendous mistakes that courts have made over the years and accretions of power. But one of the things that I love about the judiciary, and that one of the things that attracted me to a career as a lawyer, was that it is the ultimate level playing field. No matter how much money you have, no matter how much power you have, when you get to court, you have the same number of pages in your brief, the same number of minutes of oral argument, the same opportunity to present witnesses as the other person. And of late, for reasons I'm not really sure about, I often think of a case that my colleagues and I at the Institute for Justice litigated in the 1990s. It was a case involving eminent domain. A lady named, a lady in Atlantic City named Vera Koking had lived in her house for many years. She was widowed there. She wanted to live out her life in that house. And unfortunately, a very rich and powerful local developer had other ideas. He wanted that property to use as a parking lot for his limousines. And so he went to the city of Atlantic City and said, you know what, I'd like to have that property. And the city said, we'll use eminent domain to take that property and give it to you. And I'm happy to say we went to court, and as an example of how David can defeat Goliath in the courts of law, we won. Well, it turns out that the story has a very happy ending for everyone involved. Vera Koking was able to live the rest of her life in that house. The developer went on to be elected President of the United States. And my colleagues and I can say that we beat the President of the United States in court. How much better can it get? I want to thank you for having me. I'm delighted to take your questions, and I just want to finish by saying, go get them. Thank you so much for having me. I want to say, and I apologize for not saying this before people wrote their questions down, there are 3 areas that I cannot comment on. One is cases that are currently pending anywhere. I mentioned the immigration cases before as an example. Secondly, any issue that's likely to come before my court. And then finally, politics. And I'm happy to be
Everyone's gonna
excused
leave.
from politics. So I may have to not answer some questions, but I'm happy to answer the questions I can.
Well, I'm going to use my executive privilege, just like, because I thought of something as you were speaking. And I was very, very impressed by the thought of that sometimes you got to go with what's really there versus, and you don't like the policy, but it is the law, it is the Constitution. Perhaps it's my myopic view, but it seems like only our side does that. Could you comment on, getting to where you want to go regardless of the law from the left? Because that's my impression.
Well, there are. I think it really comes down to intellectual honesty, and neither side has a monopoly on that. There are liberal judges and liberal scholars who are genuinely textualists and who believe they are constrained. There are conservative judges and scholars, some who pick the outcome and just go in that direction, do whatever it takes. And both of them, whether liberal or conservative, I think they do damage to the rule of law. But nonetheless, constitutional fidelity has generally been a hallmark of conservative scholars and conservative judges, and it's just the way that we see the world. It's a philosophy that our Constitution is higher law that comes to us not as mere mortals, but from a higher source, and that these are the rules that the Constitution embodies, the laws by which we should live, and we believe in them very, very strongly. And so I think that it's simply our nature to be drawn to that, and I think it's very important that we are intellectually honest, because that's the sort of thing, when people see consistency, when people say, well, this president's executive orders are terrible and go beyond this president's constitutional boundaries, but this president's executive orders don't. It's got to be consistent. You've got to believe in federalism whether your person is in charge or not. You've got to believe in the separation of powers whether your person is president or not. And now, I think it's very important for us to show our intellectual consistency and honesty.
Okay, this is a short question, and maybe it has a very long answer, but what do you think of dividing the Ninth Circuit?
I support dividing the Ninth Circuit. Having said that, it is much easier said than done. I support dividing the Ninth Circuit for one very, very strong reason, and that is that it is so large that you cannot get all of the judges in the same room for the same hearing. And as a result of that, you have competing, conflicting decisions from the very same court. You can cite this panel of the court saying one thing and this panel saying another. You cannot have that. You cannot have that. And other circuits resolve that through a process that's called en banc review, which is where they all get together and decide the case. The Ninth Circuit literally cannot do that. They cannot establish a consistent rule of law. So I do support dividing the Ninth Circuit. And it's merely a huge question of how on earth you divide a circuit that is overwhelmingly dominated by one state. It is very difficult to divide the state, because then you could get conflicting rules in Northern California and Southern California, or Eastern versus Western. and that would be and jurisdictional issues and so forth. So who gets California in their circuit is the real problem with coming up with a solution for which the problem is very, very real.
We have a variety of questions that are around much of the same topic, which is, what's a polite way to say, perhaps old and decrepit judges. Is there recourse for judges have life terms, as you stated, but is there any point in time where something could be done about that? Is there?
Well, in Arizona and some other states, we have a mandatory retirement age of 70. Wow. That is, in my view, a
Youngsters.
little, perhaps a little, as people work longer and stay mentally acute longer, that may be too young. As far as the federal judiciary is concerned, there really is very little avenue for this. There is, I know, a tremendous amount of peer pressure. If one of the judges is losing it, his or her colleagues will definitely let them know. It means a tougher burden on them. But short of impeachment, which obviously has only been done a couple of times in American history, that's the system that we're living with.
We have a few younger people in the audience, so this question came up. I think it is interesting. Which law schools, in your opinion, are good and not biased? Your opinion on law schools?
Okay. Well, first of all, if you are an aspiring, possibly aspiring lawyer, please, if you can, introduce yourself to me. I've mentored a lot of young people over the years. One of my favorite parts of my job is having 2 law clerks every year and teaching them and learning from them, especially the technology stuff. And so I really, really love my work with aspiring lawyers. You know, the world of legal of law schools has changed dramatically since I went to law school. And the main thing that has changed it is an organization that I hold in enormously high esteem, and that is the Federalist Society. They have not only reshaped law schools, but also the judiciary. I mean, they just have a tremendous impact on the judiciary. But what the Federalist Society has done, they have not taken over law schools. Conservative and libertarian students still constitute a very small minority. But what they've done is that they have, first of all, made it a congenial thing to go to law school. You have friends who you share values with. And the Federalist Society also has basically introduced the idea of civil debate into law schools. And so a lot of deans, liberal deans, have told me there would be no debates in the law school if it wasn't for the Federalist Society. And it's wonderful. So basically what that means is that any law school that has a Federalist Society is a fine and congenial place to go to school, and almost all of them have active Federalist Society chapters. Even my own alma mater, UC Davis, I had real difficulties there. 2 of the 3 years I was there, our commencement speakers were Jane Fonda and Ralph Nader, which just reflected the ideological composition of this school. I am happy to say that instead of spending my graduation day with Ralph Nader, I spent it in Napa Valley. I have never regretted that decision. But UC Davis has a very vibrant Federalist Society chapter now. It's a congenial place to go. So the key thing, and I did not know this because I didn't have any mentors when I was choosing a law school. The 2 things that are most important about a law school are, first of all, the law school's reputation, because doors will close to you if you go to a law school that's not not as highly ranked as you possibly can get into. So go to the highest ranked school that you possibly can get into. And the second part is the law school that is the most congenial environment, because it can be 3 years of utter hell. And so you want to be in a place that you enjoy being, whether that means NYU because you love New York, or Drake Law School because you love the Midwest. Go to a place that's congenial. You can tell I do this a fair amount, but I'm happy to do it on an individual basis as well.
Would you comment on some U.S. courts declaring that Sharia law is a cultural matter?
I cannot, because that is an ongoing issue.
Okay. Get rid of some of those. Add a little lightness to it. Do you really type with one finger?
I do. It is really, really fast. It's even been on TV. And back in my single days, flight attendants would always pay attention to me and say, I've never seen anything like that before. But I learned to type when I was like 4 years old. It was on one of those old, manual typewriters, and bang, 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 and it just got really fast. And I never even found a use for my, any of the fingers on my left hand. I do occasionally, hit the shift button, but it has transitioned me well to the world of cell phones, because I'm very, very fast at that too.
You said that schools are a favorite subject of yours, and perhaps related to other things you talked about. Is there a point where a judge needs to recuse themselves from a case? Those are too close.
Yes. We judges have, and judges except for U.S. Supreme Court judges, they do not have a rule of ethics that applies to them. So they basically literally have to make it up as they go along. But most state judges, if not all state judges, are bound by rules of judicial ethics. And you must avoid the appearance of bias. And that's why I told you the things that I couldn't talk about, because the last thing I want is for someone to tell me, you expressed a view in the outcome of that case. And as a result, I had to recuse myself from all cases in which I was involved in at the Goldwater Institute, and so I've recused myself from several. I had to recuse myself from a case where I own stock in a company, and that sort of thing. But by and large, judges can express views on philosophy and on cases that are already decided without tainting their view. And I hope that even those who don't agree with me, when they see my decisions, believe that I am an unbiased judge. But where in any case where I felt that I was compromised, that I knew the outcome before I looked at the briefs, I would recuse myself.
Okay. Anyone who follows the courts at all is always hears about the diametrically opposed, a living constitution versus the textualist. Where did that come from, the living constitution?
That's a really good question, to which I do not know the answer. I think that it came from a court decision, but I could be completely wrong about that. But this is one area where I regret that that those with whom we would disagree on matters of judicial philosophy have seized the rhetorical high ground. Of course our Constitution is a living Constitution. Its principles are as relevant to us today, perhaps even more relevant than they were when the document was started. So it's very much a living document. What it is not is a amending document. It stays the same unless the people amend it. So I would try to recapture that term. This is the most, if I look this good when I'm over 200 years old, I'd be pretty darn happy.
Great. This one's kind of amusing because it comes out as a declarative statement and then asks the questions, why do lawyers in general have so little respect for the highest law of the land? So you may comment on if they do, and if they do, why? Do you think lawyers...
You know, honestly, and this is perhaps even more damning than the question, I don't think lawyers think about it very often. You know, they think about the area of practice in which they are engaged. And that could be wills, it could be personal injury. And that has actually been an interesting phenomenon in Arizona. With the election of Governor Doug Ducey, who appointed me. Ducey, unlike his predecessors, after judges names are sent to the governor through nominating commissions, and he has personally interviewed every single judicial candidate in the state of Arizona. And these are not, tell me something about yourself interviews. They are, tell me what your philosophy of the religion, the free exercise of religion versus the establishment of religion. What's the best U.S. Supreme Court decision in the last 50 years? Who's your favorite justice and why? And you know what? A lot of people go to that interview and they have no idea what their answers are to these questions. And so I actually think that ignorance is worse than an active disdain, because you can at least engage someone with an active disdain. I think that most lawyers just don't give the Constitution very much thought. And part of the remedy of that, I try to be a part of solutions to problems I identify. I'm making my teaching debut this fall at ASU. I'm going to be teaching Constitutional Law 2. And what I want to teach my students, and I really hope I am able to do this, is not just what the law is, but a love for our Constitution and a love for constitutional law. And if they have that, even if they go into water law, they're still going to be reading U.S. Supreme Court decisions and internalizing them and analyzing them. And if we have lawyers who really care about the Constitution, boy, that's a huge part of the battle.
Good answer. We talked a few minutes ago about dividing up the Ninth Circuit. This question is, what would it take to divide the state of California in up to 2 to 6 states?
I have no idea. I would like to hear from you how are you going to do it?
I've heard 2 and 3. 6 might be interesting, divided into 6 little states. We had a couple questions about Article 5 and the Convention of States. Would you like to talk a little bit about that and your thoughts on it?
So this is a very controversial subject, and that is whether the people should invoke Article 5 of the Constitution. I know there's some enthusiasm for that idea. The framers in their wisdom gave us not one but 2 ways to amend the Constitution. The convention idea has not been used since the 1780s, but it is a mechanism that the people themselves can use to alter the Constitution. There is a tremendous division among conservatives, and it's one that I hope does not spill over, because the people on both sides of this debate are of entirely good faith, and I hope that we'll respect each other's opinions and the good faith with which we hold their opinions. I do note, and some of you may not know this, I'm sure all of you know that former Senator Jim DeMint stepped down as president of the Heritage Foundation. He has now joined the Convention of the States idea in a formal capacity. I tend to support the idea, and I'm not hugely educated on it, and I'm certainly not directly involved in the effort. But I think here is the ultimate safeguard of a convention. I know people are terrified of a convention. 38 states have to ratify any constitutional amendment that is proposed by a convention. If we have 38 states ratifying an anti-freedom amendment, it's done. We're done, all right? And I don't think that will ever happen. And as a result, I'm not as concerned about the negative aspects of a constitutional convention. The positive aspect is that oftentimes when the people begin exerting this view, Congress responds in a positive way because it puts tremendous pressure on them. I'm going to give you just one really quick example that I am enormously proud of. It's not the convention idea, but the Goldwater Institute started an idea called right to try. Some of you may be familiar with it, and it's a state provision that says that individuals with fatal diseases have the right to choose, the right to access medicine that is experimental and not approved by the FDA, that has been gone through clinical trials. Well, the states may not have the power to do this. This idea spread like wildfire, and now over 30 states have approved it, including Governor Jerry Brown signing California's law to this effect. We thought that the FDA was going to file a lawsuit to challenge this as a violation of federal sovereignty over international commerce. We were sure that was going to happen. We were preparing for the litigation. Instead, they backed down. They changed their process, which took months to apply for an individual use of an experimental drug. And almost no one had the resources to do this, or the time in many instances. They cut that down to a number of hours. And that's what I see potentially happening with the convention idea. Is it's a tidal wave, it's a tsunami, and Congress responds in a way that it wouldn't, because the last thing it wants is to have its hands tied with a constitutional amendment. So that's really, it's a fairly pragmatic perspective that I'm voicing. I could be dissuaded from that. But by and large, it's an idea that I think is a good one, and the framers intended for us to use it.
That's a good answer. Okay, we'll end with something a little philosophical. When evaluating a law for constitutionality, which is more important, the perceived intent of the law or how the law will likely be implemented?
That's a really good question. How the law will be implemented or the perceived intent. Well, first of all, as I've said over and over again, the text of the law is what's crucial. And just to give you an example of that, segregation was widespread when the 14th Amendment was passed. But the 14th Amendment guarantees equal protection of the laws. If we interpreted it according to what the framers meant, we might have segregation today. Instead, the courts rightfully, ultimately, interpreted it in accord with the plain meaning of the language of equal protection and the philosophy underlying that. And I think that's the right thing to do, even when it leads to an outcome that you might disagree with. After that, I think that, this is such an interesting question, I think that intent is much more important than how the law will play out. Correcting its own mistakes is the role of the legislature, not the role of the courts. And in fact, this is a Scalia quote that I absolutely love. He said, Congress passes crazy laws all the time. He said, our job, if they send us garbage, is to send garbage back. Garbage in, garbage out. And that really, I am very concerned about the effects of such things sometimes, but we are not in the business of correcting legislative errors. We are in the business of enforcing the will of the people expressed through legislation unless it violates the Constitution.
Okay, that's it for tonight. Ladies and gentlemen,
Thank you
Justice
so
Clint
much.
Bolick. Thank you.